We have a quorum for the meeting. Let us invite the administration team to come in. At the same time, we can deal with the first item on the agenda, and that is confirmation of the minutes held on the 19th of March 2013. The draft has been sent to members via CB 1870, 12 to 13. The clerk has not received any proposals for amendments. Members, can we please confirm the minutes? Thank you very much. Minutes are confirmed. We'd like to thank the officials for attending the meeting. I shall not introduce you again. We have the meeting from 10:45 to 12:40, and the relevant papers have been sent out to members. Paper 869, 01 to 04. We'll ask the administration to, first of all, take us through the relevant papers. First of all, the response to issues raised by members at the meeting on the 9th of April. Mr. Ho. Thank you, Chairman. Good morning, members. At the last meeting, we have actually forwarded a few papers, and I am now going to introduce CB bracket 1869, 12 to 13 bracket 02, which is about the rule against perpetuities, RAP, and the rule against excessive accumulations of income, or REA. Chairman, I'm aware that at the last meeting, Mr. Albert Ho had a lot of views about this, but he is not here in the room today. But never mind, let us carry on. Well, the experience last time was that when he comes back at a later stage, he might ask the question again, but never mind, let's carry on with the meeting. Chairman, our response is that actually in the LegCo brief and also at the last two meetings, we touched upon the same issues. First, the abolition of these two rules. The purpose of so doing is that we have made reference to the arrangements under the common law, and in fact this is from the industry itself. If we look at different jurisdictions using the common law, it is said that there has not been an absolute abolition of the RAP. If we do it in Hong Kong, we may be able to attract business to Hong Kong. In the paper, in the annex, we have listed a comparison of such jurisdictions, including the UK, Singapore, Australia, and New Zealand. If you look at the REA, that has been abolished in most other jurisdictions. Last time, the more controversial view was about the RAP. And we are aware that in Australia, this was mentioned by Mr. Albert Hill. He asked about the situation in Australia. The subject is different in different states. For example, in the state of South Australia, the RAP has been abolished. So it is not the case that in modern common law jurisdictions, this is something unprecedented. But of course, the angle is, if there is no fixed period, then would it cause the use of the estate in such a way that there would be some social impact? In the paper, we have analyzed this issue from different angles. Number one, as we have seen in the past, let us look at the UK because this has originated from the UK. This was about land considerations. And as we said, and now we reiterate the same point. In the latest review of the law, the UK did not absolutely abolish the law, mainly because of considerations on land. And in Hong Kong, we don't have freehold land. So the consideration in the UK does not apply to Hong Kong, and we actually have no concern about that point in Hong Kong. As for the complexity issue, we gave that some consideration again. In Hong Kong, now we have the rule RAP, and we would actually look at the lifespan of the last life in being, and in fact there is this wait and see rule. And in para 9, we state that maybe the person or the settler has had that wish, but that wish would have been frustrated, and to the settler, since this is a possibility, this will be less attractive to him. And in Hong Kong, if we abolish the RAP, and if so, the settler's wish would be established, then of course Hong Kong will become so much more attractive to settlers. And also last time, we said it might not be totally about land, because in a trust, there may be other assets as well. But as we said last time, when it is in custody by a trustee, the trustee will have to invest the relevant asset. And so in society, the assets will be in circulation. So this is not the same as land. If land lies in waste, it lies in waste. But in terms of assets, they can be invested. But this is not something absolute, of course. Whether we should have an absolute abolition or not abolish the rule, well, we could think about the extent to which it should be done away with. If it is a commercial consideration for attracting capital to come to Hong Kong and make use of Hong Kong as a trust domicile, and if we contrast this with a principle, meaning that some assets may not be fully utilized, well, this is a relative comparison. From the industry, from experience overseas, we can see that even if we have a longer fixed period, and also if you look at the state of South Australia, we have not seen any concerns about assets apart from land, whereby if the fixed period is too long, that there will be a negative social impact. That is something we have not seen. This is for members' reference. So all in all, we believe we have struck a balance. We believe abolishing the RAP should be acceptable in Hong Kong, and it will be beneficial to the trust business in Hong Kong, so we can have more foreign capital coming to Hong Kong. Thank you. Chairman. Mr. James To, Chairman, I have a basic question to ask. You say that there could be a perpetual trust. The concept itself, are you saying that in the Hong Kong jurisdiction you can set up a perpetual trust? But then what about the assets within this trust? They can be spread all over the world. Or is it that the assets within this trust must be Hong Kong land or Hong Kong assets? The two are different. I'm thinking about this possibility. I understand that Hong Kong land is only leasehold land from the government. Supposing, well, let me quote an extreme example. If you really open this up, Hong Kong becomes so attractive as a trust domicile. And if Hong Kong land can be covered in a perpetual trust because the Hong Kong laws permit that, then in the extreme case, people from all over the world will come to Hong Kong to set up trusts holding Hong Kong land. And in the end, many well-off people, many funds or even family businesses would be controlling Hong Kong land for a period of time, which is maybe akin to perpetual possession, and they may remove the land from the market. And the paradox is, and in fact I already have this observation now, how should I put it? People are talking about this. Supposing there is this luxury development in West Kowloon, they say that mainlanders come to Hong Kong to buy flats, but they may not live in them. They use them as a big safe box. They put a few paintings, they put tens of millions of cash in that flat. They use it as a safety box. And in that case, such assets are removed from the Hong Kong market. They do not rent it out. They may put the ashes of their ancestors there and also their assets in the flat. It may become their ancestral hall, so to speak. If mainlanders and other people all over the world come to Hong Kong to do this, then there will be a big chunk of usable and useful assets which will be removed from the Hong Kong market, so Hong Kong people cannot use them. This is my worry. Of course, your argument is only one, and that's in para 6. You would say that after 50 years, any land will be taken back by government. But would that really happen?
But would that really happen? Would the land be resumed? Would there be a land premium slapped on it, the 3%? You know, we do that even now, but that is still held in perpetuity. Now, if that includes all the land in Hong Kong, then you have to bear this in mind as well. Hong Kong is very small, that's the thing. England, for instance, would be much bigger. Of course, the population is bigger as well. But if it comes to a certain point where the country can still afford to do so because there's still a lot of land supply, but in a place such as Hong Kong, which is so small, it becomes problematic right away. So I'm just thinking whether the government should rethink this. Well, your answer is can be very simple. Let's leave this for the future. Let us, discuss this at the time to cut off this perpetuity. But I do not know whether that is your response at this point. But I think it would be very complicated and very confusing if you leave it to the future, because you're forcing the person to sell his so-called ancestral home or hall where he places his ancestors' remains or incinerated remains, etc., what have you, whatever they put in there. That would be pretty messy. Yes, I welcome that view, considering the matter from different angles. Let us talk about land. There was a background paper which we forwarded in the last meeting. But of course, if there should be any resumption of land, we are talking about the land in Hong Kong. But of course, the land assets included in the trust can be land outside of Hong Kong as well. So we are, and that would, let's say, if it's land in England, it will come under British law. And of course, in the trust, there can be all sorts of different assets. We are referring to the assets in the trust of Hong Kong land. basically. And we're trying to increase the attractiveness of Hong Kong as a domicile base for trusts. Now, you mentioned an example where a residential apartment is used for certain functions, and there are some safe deposit box inside the residential unit, and the residential unit is passed on from generations to generations, and that is the asset, that is the unit is privately owned. Now I want to cut him short. What about Hong Kong? Is it 120 years? Is that 120 years? We suggest perpetuity. Now, we are not talking about land. We are talking about private property here. Mr. Chairman, perhaps I should interject very simply. I just want the government to consider Hong Kong land in Hong Kong, held in the trust, whether there should be a term to it, a time period to it. I'm not saying a diamond ring that's deposited in a safety deposit box in Hong Kong, and if the bank continues business, well, I don't mind for the diamond ring to be held in perpetuity. We're talking about land in Hong Kong, really. Yes, you're talking about land and property built or constructed on Hong Kong land. Let me ask Mr. Yu, my colleague, to answer your question. Yes, yes, within the realm of the trust, land held in trust, Hong Kong land. Yes, just to supplement Mr. Patrick Ho's point, let's say in the UK, if there is land held in the trust, then the beneficiary will have to be the trust will have to give over the land to the beneficiary at a certain point, 125 years. But the beneficiary does not have to put the land into the market right away. That is to say, there is a time limit to when the beneficiary will receive the land from the trust. But whether that will go into the market and how he deals with it, that is another issue. Now, Mr. Ho was talking about the worry that we have for land, because in Hong Kong we have the leasehold limit. Now, if it's post-1997 lease, it is usually 50 years leasehold for Hong Kong land. Now, apart from this, there are other ordinances which provide for forced sale or resumption of land by the government. So the need for this land time limit to the land is much lower compared to the UK and some other jurisdictions. Well, your measure of cutting short the leasehold is one case, but in fact it is usually, the land can usually be held for 50 years. For land resumption for public purpose can take place, but there is a situation where you may think that the person is still using the property. Let's say the residential unit was still being owned by the person and also the trust, and it's still being used, electricity used, etc. And in fact, the trust had locked up this vacant, usually vacant property unit, even though the government may be thinking of redeveloping that piece of land. But on the other hand, the residential units are still being used by these wealthy people. Let's face it, these are usually wealthy people who set up trusts. Now, let's say 80 years from now, 100 years from now, if there's insufficient land supply in Hong Kong, what can the government do then? Perhaps we should come up with certain principles. Let's say 100 years or 120 years is the first layer of resumption of the land, then we should build that in for Hong Kong as well. Now we go back to the case or the scenario just now, 125 years for the UK, 150 for other jurisdictions, etc. I think the property, the building, will have to be pulled down by then, because we are talking about over 100 years from now, perhaps 120, 150 years from now. So we have not seen buildings standing or high-rises standing longer than that period. So one can think that, well, actually, I cannot see how the building can continue to be occupied unchanged. So there would have to be some decisions made to redevelop the site or pull down the building, etc. So the scenario as described by Mr. James To just now is unlikely, that there will be 1,000 units in this building and they're all sold to different owners. But really, looking into the future, do we have to worry about that future and the possible scenarios in that future which may or may not happen? And because of that, we avoid the abolition of the RAP. Or perhaps, on the other hand, should we be more conservative? Should we build in a longer time period, well, which is not perpetuity, but it is long enough so that the possibility of that scenario happening is lowered? So I would adopt this attitude, and that is, well, we can either be conservative or to say that we understand Mr. James To's point, but thinking ahead, if it is difficult to imagine a situation where the building will be held by different owners, the units will be held by different owners for over 100 years in the same building. Well, actually, the world is very big. When we talk about perpetuity and this rule against perpetuities, basically we are thinking about trust and having the trust domicile in Hong Kong, and the trust can hold a lot of different assets flung all over the world. But we are really focused on the land in Hong Kong when I made that point just now. Yes, the world is very big, but for Hong Kong, let's say, trust domiciled in Hong Kong, and it holds a piece of land in Australia. The piece of land in Australia perhaps does not have this rule against perpetuity, but that may apply for the Australian site. But what about Hong Kong? I'm just focused on the Hong Kong land. Well, I think the government has been very clear in explaining its principle. We are talking about a long time away. If you want the industry, trust industry to develop, you have to strike a balance between worries of a long time into the future and this present situation. Now, for Hong Kong, even without the trust issue, there are a lot of assets which are frozen in Hong Kong. The problem or issue already exists. Well, I'm sure the government has noted this. 80 years from now, if it is proved true that the scenario as described by James To does happen, then we would have considered it. Yes, just to pick up on the point raised by Mr. To on perpetuity. Whether there is perpetuity or not, the concept has to be very clearly distinguished from privately owned assets or property. Privately owned property, as long as it is entitled to by the beneficiary, then the beneficiary would be able to control the property concerned. The Singaporean situation is very similar to the Hong Kong situation. In reviewing the relevant ordinance, how did they consider this RAP? I'm looking at CB1 869 12-1302. There were 3 points there concerning, as background to the abolition of RAP and REA. The 3 points, A, B, and C. I'm looking at B there. I agree that the rules are overly complex. And what we need to consider now is whether we should abolish the RAP or put a very clear, definite time period to it, whether it be 125 years or 150 years. That is not the consideration here. But going to C, I remember the last meeting, Mr. Liu and other members had raised the question whether with abolishing RAP, you are indeed able to attract a lot of business to Hong Kong using it as a trust domicile. Now, the government had provided us information as to the Singaporean experience concerning the abolition of the RAP. But why did they finally came up with a time period and not abolish it altogether? Well, this is all conjectures, how it's going to impact the industry, the market. But on the other hand, we should give more flexibility for the trust and the beneficiaries to manage their assets. Now, if there is still the perpetuity law, then in fact, after 120 years or however many years, the assets will still be handed over to the beneficiaries. That is, they will stay within the family. They will not be, let's say, resumed by the government or confiscated, so to speak. And so the family will basically have more flexibility in utilizing and managing these assets. Now, I'm looking at page 3, paragraph 7 in the same document concerning the abolition, reasons for abolishing the RAP. Paragraph 7 with a footnote 4, which refers to paragraph 3501, Leung on Trust, 18th edition.
I'd like to ask for more justifications for supporting or not supporting the abolition of perpetuity. I'd like to know the research results. In fact, I tend to agree with the principle of the DS, and that is whether we should really abolish it or we should allow a longer fixed period. Whether it be the trustee or the settler, perhaps we can have clearer rules for them to follow. Mr. Ho? Chairman, I'd like to kick off and I'll see whether Mr. Yu will supplement me. With regard to Singapore, well, we have made reference to the UK and Singapore. We've explained about the UK. We have read the Law Reform Commission and the main consideration was land. We looked at the Singapore example and we understood that actually Singapore made reference to the UK considerations. Well, whether they just copied from the UK, I'd like to see whether Mr. Yu would like to supplement. Chairman, as Mr. Ho said at the beginning, this is a matter of extent. Different countries had different considerations about having a period. But when we looked at the countries which have reformed the RAP, there was this consensus that the existing rules are too complex and that they require to be reformed. Now, as to the extent of reform, whether it should be totally abolished or whether there should be a longer fixed period, In 2009, when the UK gave this some consideration, at the Law Reform Commission there were quite a number of people who supported total abolition. But of course, there are maybe as many who said that they should be retained. And in the end, the UK and Singapore both chose to retain a fixed period. But we think we can go a little further. As for Para 7, we actually based it on a case. It showed in that case that if the trustee just allowed the asset to lay idle so that there is no interest generated, no benefit generated, then actually the trustee has already breached the trust. And so we are pointing out here that if it is movable property, including cash or shares or stocks, actually the trustee has the responsibility to invest them in the market so that there is reasonable return. And therefore, on the basis of this principle, the relevant assets will still be circulated in the market. Okay, I think basically not having a fixed period is now the administration's proposal, and the administration has already taken on board members' views. That will be minuted. If there are no other questions, let us move on. So we have already considered the two papers. Let us go to paper 04, the administration's response to views from organizations and individuals, and also paper 798 from 01 to 10. Mr. Ho, is it that you are going to take us through the paper as well? Yes, Chairman. This is a table summarizing the views of organizations and individuals. It has been given to us by the clerk, and we have responded to those views. But of course, we have read the original submissions. We have just included our response using the format that was first adopted by the clerk. First of all, there was this joint committee on trust law reform that was set up a few years ago, and there was a lot of discussion between this and the administration. This time around, from what we understand in their submission, it is said that the panel proposed that they should look beyond the bill to see whether they would like to have one or two more points included. And that is why in their submission, they have made two extra proposals which are outside the bill. First point, we can see that the respondent has given support for the major respective proposals in the bill. And then as to the first extra proposal, this is about the anti-Bartlett and Barclays provisions. Last time this was mentioned by a member, and I already announced last time that our position is such that since this provision has not been detailed in our previous discussion both with the industry and the public. Now that the industry is making this proposal, we will not object to it in principle, but in principle, we have not reached a position where we can accept it, since it has to do with this possibility that there may be some impact under the common law, and we need time to look into it. And as I said at the last meeting, we have to take this up separately. Therefore, I cannot see how we can include this proposal in the present bill, because it has not been discussed in detail. And another one, non-charitable trust. Actually, when we explained the bill to the panel, and also when we had our first Bills Committee meeting, that was already discussed. Actually, in common law jurisdictions which are comparable to Hong Kong, none of them have non-charitable trusts. But where non-charitable trusts are set up, those are in smaller countries, and those are actually offshore trusts. I don't want to use that label, but some people do label it as a haven for tax evasion. So given the present financial situation in the world, we don't like people to use this as an excuse to criticize us. So we don't consider this. In the Chinese General Chamber of Commerce submission, they included some expectations, and it is said that there should not be excessive regulation and undue pressure exerted on the trade. We note that, and we note in particular, and also at this Bills Committee, we have already discussed this before, and that is that whether we should exempt professional trustees from liability using gross negligence or reckless act as exemption. Well, we have said many times that we should go for gross negligence, but we note that actually CGCC supports what we propose to do. And for Hong Kong General Chamber of Commerce, we understand the view that we might be conservative, that more could actually be done. We are of the view that, overall speaking, we should have some kind of trade-off. And this goes to show that the RAP proposal perhaps is the only area where we have moved even further than the UK and Singapore. But we, of course, would have to go through really serious discussion before we go for that. So it is not that all our proposals have just followed the examples of the UK and Singapore. And our position should be that first, we should catch up with other jurisdictions. And secondly, is it that there is something unique that we can go for? If yes, then we will include it in the bill. Otherwise, we shouldn't rush into anything. If we are talking about offshore markets, we don't think we should compare ourselves with those. And then Chinese Manufacturers Association of Hong Kong, it supports the bill. And then on RAP, it says that it has been a long-standing practice, and whether it should be changed now. Well, we note their view. By that I mean that the RAP discussion cannot be based on comprehensive data comparison. You can say that it depends on your position and whether you want to tend to be conservative or you prefer to go for some changes. And of course, the view from this association is that it is asking whether we should change it, since it has been with us for a long time. The Law Society of Hong Kong, it has also mentioned whether more can be done. Well, certainly, we don't want to do a piecemeal job. We have not done any piecemeal reform this time around, but actually we have embarked on a comprehensive review of the law, and we have come up with different legislative proposals. And if the LegCo can support the bill, we would be a quite advanced place for setting up of trusts. The HCAP, Hong Kong Association of Banks, they have mentioned technical proposals. When we do clause-by-clause examination of the bill, we can take those up. on RAP, it has mentioned 150 years. And when I replied to Mr. James To, I quoted that example already. And I believe we have noted the view already on RAP. Then a law firm, Baker and McKenzie, it supports the proposals, including the abolition of the RAP. It supports it. And then Zurich Insurance, Hong Kong. It has asked for clarification of certain matters, and by asking questions in our response, we have already given the clarification. And actually, those are not really big problems. For example, that if there are clauses that target insurance, and they say there are different types of insurance and what are covered, we propose to increase the default powers of trustees who can take out insurance. And we have already said what types of insurance can be taken out. But then if the policy has something to do beyond insurance, then we will have to look at the default powers of the trustees. And it will depend on whether somebody would challenge that there is ultra-virus arrangement under the common law. This will have to go to the court, because after all, the trustee can be supervised by the settlor in all these endeavors.
And then there is an individual, Mr. David Gunson. He's come up with certain views. For example, in the power of investments, in our Schedule 2, second schedule, there are certain reservations. And apart from some of the bigger companies setting up trusts, there are individuals and smaller companies as well. So this Schedule 2 is useful for this purpose. For some more straightforward trust arrangements, then through relatives, through friends, the settler can set up these trusts and also make investments under that trust. So this will be helpful for persons who are less professional in setting up and managing these trusts. So that is the response. What about the Bar Association? They have not made a submission yet, but they did say that they will make a submission. Perhaps the Secretariat can liaise with them. Yes, Mr. Leung. Now, of all the views submitted, most of them are in support of the reform, but at the same time, they point out 2 to 3 issues of concern to them. I have a couple of questions. First of all, Mr. Ho, for non-charitable trust, I know the government's stance is that if we are to consider non-charitable trusts, we may be labeled by certain countries that we are a tax haven. But actually, for non-charitable trust, the main characteristic of a non-charitable trust, what is it? Why cannot be more advanced in our thinking as to why we cannot include this? Well, for the anti-Bartlett versus Barclays case, our attitude is less accepting compared to that. What we have to do is to look very deeply this possibility of attack on Hong Kong as a tax haven within our given frame of work. And we have to be very clear about that. So at this stage, we will not be considering opening this up because we do not want to be labeled that as a tax haven. And why do we have to have legislation? Because for non-charitable trust, the beneficiaries are very clear. You can say, or one can say, that this has to be resorted to, or this form of non-charitable trust has to be resorted to set up a trust for a given purpose. But if the beneficiary is unclear, or if there is no beneficiary, then in its actual functioning of the trust, the supervisory bodies and the regulatory bodies will find it very difficult to regulate. And it is perhaps through this kind of platform or vehicle that there can be tax evasion, and the regulatory bodies would find it very difficult to do anything, especially for countries which are active in the financial markets. They are also very wary of this, and so should we. There's another point I would like to raise concerning trust companies regulation. In the present stipulation, there is a small part concerning the regulation of trust companies, but at the same time I also note that certain views submitted talk about licensing regimes. But in fact, we already have a licensing regime, don't we, for trust companies? Do we maintain the present framework, or do we have to enhance regulation on trust companies? Have there been studies in this regard? Now, let me clarify. For trust companies, within the law over the many years, it does not come under a regulatory regime as such, but they are voluntarily registered, and there is no particular requirements as to who can become a trustee. But if a trust company is set up and they conduct business and they do their marketing, then they will have to abide by the law and be able to live up to certain requirements, including capital requirement, etc. And in the UK, there is a type of trustees which also have to have £250,000 in capital and £100,000 in cash. So this is something similar to the requirements in Hong Kong. And this is all new. And the reason why it is not new is because Hong Kong did refer to the UK legislation in coming up with this law in its outset. And Mr. Chairman, I would like to know whether the government feels the need to regulate the trustees. Well, over the years, I do not see a lot of problems, though. You mentioned that there should be capital adequacy and that it should be registered and the trustees can conduct business. But can the government say that they have already conducted a study that there need not be further regulation, let's say under the SFO? Well, at present, Mr. Chairman, we do not see the need. But I think in the previous meeting we have talked about or discussed trustee-related or trust-related situations, such as the MPF. The trustees in the MPF accounts are already regulated under other ordinances. Yes, I also would like to see some regulation reasonable level of regulation. Yes, Mr. Chang Paul. Yes, we have seen the views submitted. I think the most important would be the first one, Joint Committee on Trust Law Reform, Joint Committee of Society of Trust and Estate Practitioners. And Mr. Ho just now had also responded to the views. And last time, in the last meeting, you also mentioned that there will be a 2-year time period for the review. I think that is unchanged. I do not want to see that this is completely shelved. I would want to see that there is follow-up responses to the issues within a short period of time. Now, I see certain technical issues mentioned by the various by the Association of Banks. Have you responded directly to them? Have they come back with further issues or further responses to your response? And also Zurich, the insurance company, have you responded directly to them? And have they sought clarifications? And as you know, the filibuster is about to begin, and we cannot really conduct effective meetings, and I do not know when the chairman would be able to put a stop to the filibustering effort, and I do not know when we can resume meetings. Chairman, do you have a view on that? Yes. I will respond to that question in AOB. Perhaps Patrick Ho can respond to your questions. Perhaps I will ask Mr. Yu to talk about the responses. Well, first of all, the Hong Kong Association of Banks, in fact, they have submitted their views to us. And also, we have met with them, and they have repeated their views in this submission. There are some new points, and we have already prepared the response to these new points, and we have forwarded the same to the Secretariat, and we will wait for the Hong Kong Association of Banks response. Well, perhaps we can be more proactive because they are a very important body in the industry. Perhaps we should write directly to them. I do not know what the practice is. Do you actually respond directly to the organizations or individuals which have forwarded their views to us? I think for technical issues such as these, it is difficult for us members to respond to them. But on the other hand, if you have responded to them directly, written to them directly, well, you said you've uploaded them onto the net, but do they read them? Well, the practice is that when we respond to the organizations having made the submissions, we actually go through the Secretariat of the LegCo. And if there should be a response from these organizations, the responses will go to the Secretariat and also to the chairman. I would like to know from the Secretariat what the usual practice had been, especially for those bodies which we do not directly consult. Well, I think it is a good practice for us to respond, at least for this time, to respond directly to the Hong Kong Association of Banks so that we know whether we need to follow up, so that we have sufficient information, and if time allows. But of course, if there are some new points to be made in their response to the government's response, then we would like to look at those as well. Anything to supplement the Secretariat? Did the Secretariat respond to the organization submitting their views? Well, actually, for the government's responses, we do dispatch them to the organization submitting the views. For certain panels, well, if the committee is of the view that we should do that, we will do so. Well, yes, these are very professional bodies. I think we should respond to them, and if they have any further responses, we should consider them in our clause-by-clause discussions. Well, if that is the case, yes. Apart uploading onto the website, perhaps we should also respond to the organizations saying that we have taken up their views, or we have discussed their views, and we come back to them with the response, and then if they have further points to make, then they should respond to us, and then we will, and the government can further respond to that. And if the government feels that it is necessary, as Mr. Chan had pointed out just now, if there are some very technical or professional points which the bodies would want you to directly liaise with them because the issues are technical in nature, we have no objections to that as well. All right, so the consultation is actually it comes from the chairman of the committee through the Secretariat. Now, that resolves my third point as well. As explained just now, we do go through the LegCo Secretariat, then I'm clear on my third question as well. Now, going back to the first question, and what was the first question? Well, the first question was, will you be reviewing the non-charitable organization and settler issue within 2 years? No, I have not changed my mind. That remains so. All right. AOB, the chairman would want to respond to my previous question. Yes, the 7th of May, we should have a 4:30 meeting. But I would want to say again that if there is a full council meeting, which takes up the time slot, then we may have to forego this May 7th, 4:30 meeting of ours. So please mark your diaries for May 7th, 4:30. But on the other hand, if there is a full council meeting, then we will have to postpone the meeting. And when will it be postponed to? We will have to decide later on. Noted, Mr. Chairman. I do not want to see that the committee meetings be postponed indefinitely and the work of the LegCo be delayed. I hope that the chairman can reflect this to the council, that the filibustering can be seized as soon as possible. Yes, I will reflect this point to the council, and would the Secretariat please note this in the minutes.
Mr. Kenneth Leung, Chairman, after a few meetings, I think the DS would now have to go back and take a look again at perpetuity. You are now talking about abolishing the rule, but should it be abolished or should you allow for a longer fixed period? Perhaps you should ask the industry again whether that is a strong view for abolition RAP. I want you to report back next time. I think this boils down to a debate about principles because neither side has concrete data to support the argument of abolishing or allowing for a longer period. You talk about the state of Southern Australia, that the RAP has been abolished there. It is a big place and it may be in a different position from Hong Kong. That is an example for our reference, but it is not in the same position as Hong Kong. Now, if we can have that meeting, and Mayor, I hope you will give us a formal response. But I'd like to ask you whether you would give it further consideration. Okay, the Deputy Chairman has already indicated this wish more than once. Okay. We can wrap up the consideration of views from individuals and organizations, and we are still awaiting a submission from the Bar Association. Since we have read the papers, I'd like to ask members whether you would like to invite these organizations or individuals which have given submissions to come in person to LegCo. Do you think there is such a need? Mr. Dennis Kwok. Chairman, I think there is such a need because the organizations have written some very long submissions. I believe it is worth our while for us to hear directly from them and to see whether they have questions to ask after looking at the response from the administration. So, okay, this view is such that we should ask them whether they're interested to come to LegCo. Only one organization said that upon invitation, it would be quite happy to come. And this is the Joint Committee on Trust Law Reform. Mr. Ho? Sorry, Chairman, I'd just like to say whether members would consider having a hearing on a particular topic or on the bill as a whole. Because, in fact, some of the submissions did not actually raise questions and did not contest any points in the bill, except the Hong Kong Association of Banks, which has raised some technical questions. So perhaps the two industry bodies might have further views to submit, but this is only my proposal. So do you want a general hearing on the bill, or would you like to have a hearing on a particular issue? Mr. Dennis Kwok. The DS view is very good. Actually, the point of controversy, let us not say it's a controversy, but the topics are just RAP and the anti-Barclay and Barclays exemption. Then maybe we can ask them to speak on those few points. So you're inclined to have a focused hearing. Mr. Chen Kin-po, Chairman, if we are going to invite them to come, they should have already taken on board the initial response of the administration. They should not just come here and repeat their submissions. Remind them upon invitation that they should give updated views instead of just repeating what they have already said in the submissions. I think there should be an updated kind of hearing. Okay, so summarizing members' views, I think you're saying that we should collate the response of the administration and send them to the organizations which have written in, and then would ask them whether they would like to respond to an invitation for them to come here to respond to the administration's response. Okay, so if you agree, we'll ask the clerk to consolidate the few issues we'd like them to speak on. And also, Chairman, they should respond to the administration's response. Yes, first, we will allow them to have the administration's response to organizations and individuals which have written in, and then we'll tell them that we'd like to focus on a few particular topics, and then we'll ask them whether they would be interested to take up our invitation to come and speak to us again. If we would receive their replies, then perhaps we can devote one meeting to hearing from them. All right? So we'll do that. The clerk, you should forward the administration's response to these organizations and then tell them we'll focus on a few points. DS, would you agree to our doing that? Thank you, Chairman. Okay, in the time left, before we do clause-by-clause examination, is it that we are duty-bound to listen to all deputations and individuals first? Is it that we should first listen to them before we go into clause-by-clause examination, or is it that we can first start with clause-by-clause examination? Members, what do you think? We have only 2 members left, apart from myself. Chairman, I tend to be conservative. I think we should first listen to them. I think we are just talking about one more meeting, because if you look at the summary of views, there are not too many organizations which have given a detailed submission. Maybe we can wait for another meeting to listen to their views first, because I'm afraid if we start with clause by clause now, the provisions may not be directly related to those viewpoints we'd like to take up again. However, if we are talking about consistency in the bill, then there might be a problem later. Chairman, there are a few issues. If we now start with clause by clause, then when we receive the deputations, they might say, look, or if some other members would join at the next meeting, they would say, have we really threshed out all the major principles? I think I tend to agree with Mr. Kenneth Leung that first of all, we should remind members who have not attended this meeting to tell them that we are embarking on clause by clause very soon, and ask them whether they have any views in principle, because I don't want to go back and forth. And also, as Mr. Kenneth Leung said, the deputations might have other things to say, and I think we are a very small group today, and in fact I really rely on members who have legal knowledge and legal background to help us scrutinize the bill. I hope they will attend our meetings more. Yes, I agree with you. Once we go into clause by clause examination, that can become quite technical, and if we have to revisit the matters of principle, then it might complicate matters. And also, we have a small group. I don't know the reason why members are not attending the meeting. So I hope the clerk will remind members in the notice of the next meeting that we will be conducting a hearing at the next meeting, and after that we'll go right into clause by clause examination of the bill, and members should state what they think about the major issues or principles in the bill, instead of bringing them up after we have started clause by clause examination, because that might have an impact on the progress of the meeting. So remind members about that, even if they cannot attend the meeting, because we don't want to go back and forth. All right? If that's the case, if there is nothing else for today, and since we are just a small group, I don't think we should start clause by clause examination today. We will wait for the hearing to be conducted at the next meeting before we start clause by clause. If you agree, we will end the meeting early today. Thank you very much for coming.